Salalima v Ginguna, Supra. In Salalima v Ginguna, Jr., the court en banc categorically ruled that the office of the president is without any power to remove elected officials. Since the power is exclusively vested in the proper courts as expressly provided for in the last paragraph of Section 60 of the LGC, it further invalidated Article 125, Rule 19 of The court nullified the rule since the Oversight Committee that prepared the rules and regulations of the Local Government Code exceeded its authority when it granted to the disciplining authority the power to remove elective officials, a power which the law itself granted only to the proper courts. Grego v. Cumlick 274 SCRA 481. Facts: on October 31, 1981, Bosco was removed from his position as deputy sheriff by the court upon a finding of serious misconduct in an administrative complaint lodged by Nina Tordesillas. Subsequently, Bosco ran as a candidate for councillor in the 2nd District of the City of Manila during the 1988 local elections. He won and, accordingly, assumed office. After his term, he sought re-election in the 1992 election. He again won. However, a case for quo warranto was filed by Senan Ronquillo, who alleged Bosco's ineligibility to be elected councillor on the basis of the Tordesillas ruling. Other complaints were filed before the Office of the Ombudsman and in the DILG. In 1995, Bosco ran again for councillor. William Grego, claiming to be a registered voter of precinct number 966, District 2, City of Manila, filed with the Cumlick a petition for disqualification, praying for Bosco's disqualification, for the suspension of his proclamation, and for the declaration of Romualdo S. Maranan as the 6th duly elected councillor of Manila's 2nd District. The Manila BOC however proclaimed Bosco as a duly elected councillor of the 2nd District of Manila. In view of the proclamation, Grego filed an urgent motion seeking to annul the illegal proclamation. The Cumlick dismissed the petition for disqualification, ruling that the administrative penalty imposed by the SC on Bosco was wiped away and condoned by the electorate who elected him. Issue 1 Section 40 of Republic Act No. 7160 apply retroactively to those removed from office before it took effect on January 1, 1992. Held no ratio, petitioner submits that although the code took effect only on January 1, 1992, Section 40 must nonetheless be given retroactive effect and applied to Bosco's dismissal from office, which took place in 1981. It is stressed that the provision of the law as worded does not mention or even qualify the date of removal from office of the candidate in order for disqualification thereunder to attach. Hence, petitioner impresses upon the court that as long as a candidate was once removed from office due to an administrative case, regardless of whether it took place during or prior to the effectivity of the code, the disqualification applies. We do not, however, subscribe to petitioner's view. Our refusal to give retroactive application to the provision of Section 40 is already a settled issue, and there exist no compelling reasons for us to depart therefrom. Well settled is the principle that while the legislature has the power to pass retroactive laws which do not impair the obligation of contracts, or affect injuriously vested rights, it is equally true that statutes are not to be construed as intended to have a retroactive effect so as to affect pending proceedings. Unless such intent is expressly declared or clearly and necessarily implied from the language of the enactment, there is no provision in the statute which would clearly indicate that the same operates retroactively. It, therefore, follows that 40 of the Local Government Code is not applicable to the present case. Issue 1 Private respondent's election to office as City Councillor of Manila in the 1988, 1992, and 1995 elections wipe away and condone the administrative penalty against him, thus restoring his eligibility for public office. Ratio: at first glance, there seems to be a prima facie semblance of merit to petitioner's argument. However, the issue of whether or not Basco's triple election to office cured his alleged ineligibility is actually beside the point, because the argument proceeds on the assumption that he was in the first place disqualified when he ran in the 3 previous elections. This assumption, of course, is untenable considering that Basco was not subject to any disqualification at all under Section 40 of the Local Government Code, which, as we said earlier, applies only to those removed from office on or after January 1, 1992. In view of the irrelevance of the issue posed by petitioner, there is no more reason for the court to still dwell on the matter at length. Anent Basco's alleged circumvention of the prohibition in Tordesillas against reinstatement to any position in the national or local government, including its agencies and instrumentalities, as well as government-owned or controlled corporations, we are of the view that petitioner's contention is baseless. Neither does petitioner's argument that the term any position is broad enough to cover without distinction both appointive and local positions merit any consideration. Contrary to petitioner's assertion, the Tordesillas decision did not bar Basco from running for any elective position, and with prejudice to reinstatement. In this regard, particular attention is directed to the use of the term reinstatement. Under the former Civil Service Decree, 16, the law applicable at the time Basco, a public officer, was administratively dismissed from office. The term reinstatement had a technical meaning, referring only to an appointive position. In light of these definitions, there is, therefore, no basis for holding that Basco is likewise barred from running for an elective position, inasmuch as what is contemplated by the prohibition in Tordesillas is reinstatement to an appointive position. Issue 1. Private respondent's proclamation as 6th winning candidate on May 17, 1995, while the disqualification case was still pending consideration by Cumlic, is void ab initio. Ratio: the inapplicability of RA 7166 Section 20 to the present case is very much patent on its face, considering that the same refers only to a void proclamation in relation to contested returns and not to contested qualifications of a candidate. RA 6646 Section 6 does not support petitioner's contention that the Cumlic, or more properly speaking, the Manila City BOC, should have suspended the proclamation. The use of the word may indicates that the suspension of a proclamation is merely directory and permissive in nature and operates to confer discretion. What is merely made mandatory, according to the provision itself, is the continuation of the trial and hearing of the action, inquiry, or protest. Thus, in view of this discretion granted to the Cumlic, the question of whether or not evidence of guilt is so strong as to warrant suspension of proclamation must be left for its own determination, and the court cannot interfere therewith and substitute its own judgment unless such discretion has been exercised whimsically and capriciously. The Cumlic, as an administrative agency and a specialized constitutional body charged with the enforcement and administration of all laws and regulations relative to the conduct of an election, plebiscite, initiative, referendum, and recall, has more than enough expertise in its field that its findings or conclusions are generally respected and even given finality. The Cumlic has not found any ground to suspend the proclamation, and the records likewise fail to show any so as to warrant a different conclusion from this court. Hence, there is no ample justification to hold that the Cumlic gravely abused its discretion. Since Section 6 of Rep. Act 6646, the law which Section 5 of Rule 25 of the Cumlic Rules of Procedure seeks to implement, employed the word may, it is, therefore, improper and highly irregular for the Cumlic to have used instead the word shall in its rules. Moreover, there is no reason why the Manila City BOC should not have proclaimed Basco as the 6th winning city councilor. Absent any determination of irregularity in the election returns, as well as an order enjoining the canvassing and proclamation of the winner, it is a mandatory and ministerial duty of the Board of Canvassers concerned to count the votes based on such returns and declare the result Finally, the cases of Duremdes, Benito, and Agwam, Supra, cited by petitioner are all irrelevant and inapplicable to the factual circumstances at bar and serve no other purpose than to muddle the real issue. These three cases do not in any manner refer to void proclamations resulting from the mere pendency of a disqualification case. Issue 1. Romuald S. Moranin, a 7th placer, be legally declared a winning candidate. Held no ratio. Obviously, he may not be declared a winner. In the first place, Bosco was a duly qualified candidate pursuant to our disquisition above. Furthermore, he clearly received the winning number of votes which put him in 6th place. Thus, petitioner's emphatic reference to Labo v. Kumlik, where we laid down a possible exception to the rule that a second placer may not be declared the winning candidate, finds no application in this case. The exception is predicated on the concurrence of two assumptions, namely, the one who obtained the highest number of votes is disqualified, and the electorate is fully aware in fact and in law of a candidate's disqualification so as to bring such awareness within the realm of notoriety but would nonetheless cast their votes in favor of the ineligible candidate. Both assumptions, however, are absent in this case. Petitioner's allegation that Bosco was well known to have been disqualified in the small community where he ran as a candidate is purely speculative and conjectural, unsupported as it is by any convincing facts of record to show notoriety of his alleged disqualification. In sum, we see the dismissal of the petition for disqualification as not having been attended by grave abuse of discretion. There is then no more legal impediment for private respondent's continuance in office as City Councillor for the 2nd District of Manila.